What documents in my estate plan do I need to update? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And today we're going to look at some of the documents that are properly in your estate plan and whether or not you need to update them. Now I'm going to start out this video by explaining that everybody's estate plan documents may be a little different. So I may mention a document that you might not have in your plan, and hopefully there's a good reason why you don't have it in your plan. You worked with a professional, you talked to your financial advisor, your attorney, and they made sure you had the right documents for your situation. So if I mention something that you don't have, don't worry about it. It's totally okay. However, you may want to make a note of it and check in with your attorney to see, should I have that document? So every 2 to 3 years, I always recommend to my clients that we review all of their estate plan documents. Let's make sure that everything is correct, everyone's addresses and phone numbers are the same, but there can also be some other life changes that happen every 2 to 3 years, and we want to make sure that where necessary, those documents are being updated. There's going to be 2 types of documents we deal with. The first are going to be documents where your lawyer should be involved when you're updating the document. And the second are documents that you can do on your own, but you should make sure you're letting your lawyer know that you're updating them because they need to update their files as well. So starting with lawyer documents, and the most important in any estate plan is going to be your last will and testament. This is the main document that says what happens to your assets, whether you have a guardian for your children, our trustees set up. We always want to make sure this is reviewed every 2 to 3 years to make sure we have the right people in the right roles and that everything is correct. If we're just changing someone's name or changing someone's address, we can do what's called a codicil to change the document. Or if it's time for a whole new estate plan, if it's time for a whole new will, then we can do a whole new redrafting of your will. So those are the 2 options when you look at your last will and testament. And it's important to talk to a professional to make sure you know whether we're just amending the will with a codicil or whether we need a whole new one. The second document we're going to look at is a trust. So a lot of people don't have trusts as part of their estate plan, but plenty of people do. So if you have a trust that you set up, we want to make sure that everybody, again, is in the right place. We still have the same trustees and beneficiaries we wanted to have. Maybe there's other provisions for properties that you no longer own. And so if that's the case, we want to check in with a professional and see whether or not we need to restate the trust or whether we just need to amend the trust. So a restatement will be an entire document that redoes the trust, whereas an amendment will be we're just amending Article 7.2 to say blah, 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 blah. But it's important to figure out which one's best for you. Third document will be a healthcare power of attorney. Now this one's a pretty straightforward update. This says who has the power to make health decisions for you if you become incapacitated. These updates are usually pretty quick, and it really ends up being just substituting someone's name for somebody else or updating an address and a phone number. Same with a durable power of attorney, which deals with your financial records and your financial decisions. Same principle. If everybody's still in the same place and everyone's address is still the same, we probably don't need to update this document. However, if somebody has moved or if you'd like to add somebody to the document, it's pretty easy to update. Along with your healthcare power of attorney, I usually recommend a HIPAA authorization, which allows your healthcare power of attorney agent to have access to your medical records. The HIPAA authorization really just has names in it, so it doesn't always have to be updated as long as the same people are in the same places that you want them to be, having access to your medical documents. That's a pretty easy one to decide whether or not you need to update it. If you have a living will, this is pretty straightforward. It doesn't usually change over time. However, you may want to look at it again and make sure that all those provisions in there are what you still want to have happen in case you become sick or in a vegetative state. If we're looking at deeds to your property, we definitely want to talk to your attorney and make sure that if you created a trust and you meant to move your house into the trust, but you never did a deed, well then the house is not technically in the trust yet. So we can review that deed, and if need be, we can create a new deed to move the house into the trust. And if you have a prenuptial agreement, this isn't something that you're normally going to amend. You're not going to make changes to your prenup. However, if you have a prenup from a few years ago and there's been something that's changed, you may have some issues going on in your marriage, you may want to consider what's called a postnuptial agreement. So you wouldn't really amend the prenup, you would create a postnuptial agreement. Those are very technical, not something you want to try to do yourself. You want to make sure you speak to a qualified family law attorney and see whether or not a postnuptial agreement would make sense for you. Now let's look at some non-lawyer documents. And the first and the most important one, work with your financial advisor to make sure your beneficiary designations are all up to date. If we have any accounts, like retirement accounts that have a beneficiary designation on them, they pass outside of your estate plan. They're considered non-probate assets. And we want to make sure they say who the person is who receives them, and then usually a secondary and a third beneficiary. You don't want to have You don't want them to say that it goes to your estate, because then it goes into your will and can create estate tax problems down the road, not to mention tax problems if you really mean to just roll over your retirement account to your spouse. If you have a personal property memorandum, this is something you can update at any time. Just remember to sign it and date it, because your will probably has a provision that says the most recent signed and dated memorandum is the one that will control the distribution of your property. If you have a cryptocurrency inventory, this is also something you can update on your own. I recommend updating it a lot more frequently than every 2 to 3 years. Frankly, I'd be checking in every 3 to 6 months. Crypto moves a lot faster than a lot of these other assets. We want to make sure that your inventory is up to date. Finally, if you have a remembrances memorandum, which is usually 7 or 8 pages about what you want your funeral to look like and other provisions for after you're gone, this is usually a low-level priority for people to update, but I would still check it every 2 to 3 years and make sure everything's still the same. Maybe you've moved, maybe you have different ideas of what you'd want the funeral to look like, but it's important that you're reviewing it so you understand whether changes need to be made. You don't need to go to an attorney for this, but if you have one as part of your estate plan, it's good that your attorney has a copy so that they have a copy of all the important documents for your estate plan. So we've been through a bunch of different documents at this point, some with your lawyer, some not with your lawyer, that can be looked at about whether or not you need to update them. So if you have more questions, you want to get started on the process of updating some of those documents that need a lawyer, you can go to my website, 𝙃𝙀𝙍𝙀𝙀. There's going to be a red legal strategy session button on the front page. That'll take you to my personal calendar where we can set up a legal strategy session. It's a 15 or 20-minute phone call where we can talk about where you are in the process, look at these documents, and figure out what documents need to be changed. If you found this video to be insightful, I'd appreciate it if you hit a like, and you can go, if you'd like to see more of these videos, you could subscribe to the channel. We always have videos being updated, and I will see you in the next video.